Let,
And we're live.
let
Okay, we're
me,
live. I had no idea that Dr. Billauer was as accomplished as she is. She has more degrees than
a
I.
thermometer. More degrees than a thermometer is what I usually say.
And they're both in. The fascinating thing is they're both in health and law, which gives her a different perspective and makes her a unique contributor to the work that we produce at ACSH. And she's written some incredibly good articles. And she's focusing on some issues that I want ACSH to spend more time focusing on. So I will turn the meeting over to Barbara. Go ahead.
Thanks very much, Tom. Let's see if I can screen share here. Okay. There we go.
There it is.
Now I've got to get the screen shorter. There we go.
Oh, by the way, glad you and Jeff and Nigel could join us.
Okay. I will take it away for the Salk Talk of April 2024. And what I'm going to talk about today is about scientific evidence in context. And it's really going to be a fun talk because I'm going to tell you things that a lot of lawyers don't know and hopefully give you some clues or insight into making sense of some of these very strange verdicts coming out. And what?
No. Yours? Yes. No. I'm married. I can tune out.
Perhaps people can just put their videos on mute, or would that help? Okay, so I will help understand why the cases go the way they do and make some sense of these really strange verdicts. So I have picked 10 different cases that I think will heat up this year, and I'm going to talk more about them. Shaken Baby case is the criminal case, and that has its own evidentiary issues, which I'll be writing about. And I've written a little bit about them. Some of these I've already written about. I'll write about it some more. And what I've now done is color-coded the ones where I think I can predict the outcome. The blue ones I've color-coded are the ones that I think will go to the plaintiffs. The orange and red ones I think will go to the defendants. How certain I am is how strong the color is. The three white ones I haven't figured out yet, but we'll see what's happening. But I'm going to now tell you the basis of how I got there. So these cases will all turn on either Frye or Daubert, which you've heard those names before. Frye was decided in 1923, Daubert 1973, and one or the other applies to every case or every court in the country. And they focus, or they're supposed to focus, on the admissibility of novel science. In the Shaken Baby case, the standards are being used to argue over old established diagnoses, so they're misusing it, which lawyers will do if they can get away with it. And there's an argument about which standard is better. And of course, that depends on which side of the aisle you sit. If you're a plaintiff's lawyer, you say this one is better. And if you're a defense lawyer, this one's better. And theoretically, neither should be better if you're in search of the truth. But they go in search of the truth in different ways. And I'll explain why they go the way they do and how they got there. So Frye started off in 1923. It is a criminal case, and it was not even a Supreme Court case. It came out in the appellate court in Washington, D.C. It involved the admissibility of a lie detector prototype. And the end result of the case is that scientific evidence will not be admitted into evidence unless it is generally accepted in the scientific community. And I'll explain what that means and how the court got there and why the court got there. 7 states still follow Frye. Up until a couple of months ago, New Jersey had a goofy system where they followed Frye in the criminal courts and Daubert in the civil courts, but now New Jersey's applying Daubert for everything. So 7 states still apply it, and you will see in the course of forum shopping, which is what lawyers do, what states they choose to file their cases in. Now, in some cases, they don't have a choice. But in some cases, if they can find a tie to a particular state, they can bring the action there. And for example, in the Roundup cases, the state cases were all filed in Frye jurisdictions, and we'll talk about why perhaps at the end. And so just focus on where the cases are being brought. Are the plaintiffs picking, which they do, it's called forum shopping, the jurisdiction they want to try their case in. In 1993, after the 2 decades of junk science, we had the Daubert case, and that is significant because the judge is now the gatekeeper. Beforehand, the judge could throw up his or her hands and say, okay, it depends what the scientists say, and I'm not getting involved. In Daubert, the judge cannot abdicate that responsibility. All federal courts followed Daubert and 43 state courts. And the major difference is that Daubert allows more new science. And so initially it was thought that Daubert favors the plaintiffs because the plaintiff cases involve new technologies, new chemicals. The science is not as well known or well entrenched. And Frye follows the older standard, and so that's more rigid. But there are a lot of exceptions to that. And basically, in my opinion, it doesn't make a difference which state you file. Okay, so let me tell you how Frye got to be Frye. And we need to focus on the backstory. As I said, Frye involved the introduction of the first prototype blood pressure cuff used for determining scientific evidence, used truth and veracity. So it's the first lie detector case. But the case really focuses on that gentleman over there when he was a young man. His name was William Marston, and William Marston was a character. He went to law school. He also had a PhD in psychology, and he came up with this idea of using the blood pressure to, it was only a systolic, it was not diastolic at the time, but only a systolic to tell whether somebody is telling the truth or not. He was very good friends with Wigmore, who was the leading expert on evidence, and he was a character, to say in a word. He also, by the way, is best known for being the creator of Wonder Woman comics, just to tell you that he was a rather strange man. Okay, so the case starts out with a young man named James Alfonso Frye, who was indicted for murder and robbery. And while he was in jail waiting his trial, after he had confessed to the crime of murder, and didn't confess to robbery, he confessed to second-degree murder. Dr. Marston voluntarily decided to make his new technology known free of charge. Basically, he wanted publicity. He was a major publicity hound. And he took James Albertson's Frye's testimony, or he gave him an examination in jail, and he found out, lo and behold, that Frye was not telling the truth the first time around. His confession was flawed, and now he's telling the truth this time around, and he did not commit the murder. And they wanted to introduce this evidence in court. And the judge had to figure out whether they were going to let this evidence, which would now allow Frye to plead not guilty, to be admitted into court. And basically the court said, it is too new, we're too uncomfortable with it, and so no, you can't. And what happened was Frye was convicted of murder. Case went up on appeal. The appellate court sustained it, and that was 70 years. Whatever the majority of the scientific community says, that's it. Now, the interesting thing is, let me just tell you what this is, the conflict that was distilled out of Frye. If Frye only involves new science, and the judge says it's too new for the judge to feel comfortable with, the question emerging is when science becomes accepted. And this is what law students study for a long time. We studied Kuhn on the structure of scientific revolutions, and when old science becomes new science, and when a principle becomes acceptable. And as the court says, it becomes hard to define, but they'll allow expert testimony from deduced, well-recognized principle or discovery. So that became the standard. The issue is whether it applied to novel science and what is novel. Now, what's really interesting is that the sphygmomanometer Marston's new device was new, but it wasn't. It's been around, was around since 1840. The first prototype of the blood pressure machine was called the chymograph. And basically Marston in 1915, long before the trial, started using it for trials. So it really wasn't that new, but the judge said there wasn't enough written about it and the scientific community hadn't embraced it. And so the judge wasn't going to let it in either. And Frye's conviction remained. So the question we have to ask is 1923, what did the judges do before Frye? Because Frye was such a major paradigm shift, major. So you might think 1923 was a really long time ago, and maybe their judges didn't have sophisticated scientific evidence that they had to decide. So that's not true. And I'm going to give you an example. And that comes from 1896. And the name of the case is Smith versus Grant. And it involved a young man by the name of James Smith, who fell and fractured either his left thigh or his right femur. Nobody knows exactly. And he went to Dr. William Grant, who was an orthopedic surgeon, who was very well known, very eminent to fix it. In those days, doctors made house calls. And they would diagnose a fracture by palpation, by feeling if the bone was not an integral piece, it was broken pieces, by physical signs and symptoms. Was there swelling? Was the bone sticking out? By crepitus, the sound of the bones rubbing against each other, which is what you hear if you listen to my arthritis in my neck. And Dr. Grant decided, no, he doesn't have a fracture, and he prescribed exercises, actually. And this was in June. Smith sat with his pain for 3 weeks before he got up the guts to see Grant. Grant comes at the end of June. Smith's still complaining, comes back a second time. No, Grant says, no, this is not a fracture. That's it. The next thing Grant hears is that he's got a lawsuit pending against him, a malpractice case. This was hardly the first malpractice case. This was a wave of malpractice cases. It's a malpractice case because Smith says that his leg was fractured. Now, how is he going to prove it? He brings in an X-ray, an X-ray in 1896, an X-ray in 1896. Well, that is a picture of the very first X-ray taken, and it was taken in December of 1895, 6 months before the Smith versus Grant trial. And in that 6 month time period, there were two conferences. This case takes place in Denver, Colorado. Two conferences in Denver where the medical community were schooled on X-rays. The medical community did not like X-rays because they saw how it was going to be used. They saw that it was going to be used not for diagnosis, but to prove that a doctor missed a diagnosis. And they realized that this was an offensive tool as opposed to a diagnostic tool. And so the scientific community did not like this device, and the general consensus was not in favor of it. But Judge Lefebvre, that's his house. I couldn't find a picture of him. That's his house. It still exists. It's in Denver. Says, let the courts throw open the door to all well-considered scientific discoveries. And what was so interesting was that in 1896, and by the way, this case was not the first case where X-rays were brought in. It was a case in Kansas beforehand. That even photographs, the judges were having questions as to whether photographs were real evidence or whether it was hearsay, whether it was an out-of-court statement. So the judges are wrestling with whether photographs are evidence, and now you have an X-ray which is not even taking a picture of something, it's taking a picture of a shadow. And Judge Lefebvre says, okay, let it in. Let the court throw open the door and let it in. So you have to say to yourself, well, if the standard up until that time, and there are many scientific cases beforehand in the early 1900s, 1906, when FDA came about in responses to Sinclair Lewis's book, The Jungle, and they changed the food laws. There are a lot of very complicated cases about whether margarine is butter, and the chemistry involved. I should send it to Josh, he'll love it, because it's all about the chemicals and whether margarine is butter. And so there's a lot of science all over the place. And the judges were very comfortable with science. In 1904, you had the case, the first scientific brief before the Supreme Court, written by Judge Brandeis about workplace harms. By 1903, science is no big deal. They knew how to handle science. So what's going on in Frye? What motivated the judge to handle it? And basically, remember, this is Washington, D.C., you have a Black man who's accused of murder of another Black man, not a white man, a Black man, a very well-respected doctor. And in my opinion, I think the judges knew that this was going to be a racially tainted case, and they didn't want to have anything to do with it. And so they just dumped it on the scientific community because it did not track with any of the cases up until that date. This was a paradigm. And because of Daubert, because of Frye, rather, the judges took a backseat. They wanted to let it in. They would say the science let it in. It was a really laissez-faire thing. And what happened is after Frye, the law pretty much bankrupted a lot of industries. The silicon breast cases, for example, and Tom just informed me that one of our loyal members, Jack Fisher, was thinking about attending. Jack Fisher wrote a wonderful book called Silicon on Trial, describing how the silicon implant industry was bankrupted by Frye. It wasn't just that, it was the Dalcon Shields, the asbestos cases went hogwire. And so by 1993, you had Huber writing Galileo's Revenge. You had Marina Angel who was the editor of the editor of New England Journal, writing, "You've got to do something, science has gone crazy." And in 1993, the Supreme Court had a chance to do something in the case of Daubert, which everybody's heard of, versus Maldown. What's so unusual about Daubert was Daubert creates a unique function for the judge. The judge is now the gatekeeper. The judge can't sit idly by and defer to the scientific community. The judge has to take responsibility for the science. That was the major paradigm shift. The judge is responsible. And if the judge doesn't do it, the judge has got a problem. Now, Daubert was a Bendectin case. Bendectin is a birth defect case, and the plaintiff came in with chemical structure analysis, animal studies, and a reanalysis, and the court didn't particularly like it. And so they created this role of gatekeeper to ensure that all scientific evidence submitted is not only relevant, but reliable. And here is where the court made its big first mistake. They only focused on reliable. And the court basically said legal reliability is the same thing as scientific validity. And the problem with that is what happens to legal reliability. And they don't differentiate the two standards, and I'll go over that in more detail at the end, but the case focuses on reliable, not valid, and that's where you have a lot of problems because the lawyers don't understand the difference. And when I taught scientific evidence to judges, they were thrilled that I explained the difference to them because they could then understand what was being done in the court. And I'll explain that in a little while. To help the judges make the decision about what is, quote, reliable or what is sound science, the Daubert case proposes 4 factors. There's 5 on this chart. They're non-exclusive. The judges can use anything they want. They're not mandatory. They're really just suggestions. And this is basically whether the proposal has been tested. They use the term falsified. I don't know what falsified means, actually. I do. I did my dissertation on it. But what it comes from is this. The amicus brief in Daubert, it was an amicus brief submitted by the American Association of the Advancement of Science. And at that time, the president was a friend of mine, who's now deceased, Leon Letterman, who won the Nobel Prize for the 6th court. And at that time, the physics community, well, they were cosmologists. You can't prove the existence of the world. And so they relied on falsifying it, disproving it, using Popper's theory of you can't prove anything because tomorrow you might find a black swan. You can't say there are no black swans because tomorrow you might find a black swan. And some of the things Popper has written are absolutely off the wall. He will say you can't prove anything. That people die, well, you can't prove that people die because maybe there'll be a cell like the cancer cells, so people don't die. Cells might live forever. He has all sorts of reasons. And so the falsification standard became enmeshed in law. The problem with falsification is the biologists and chemists amongst us use verification proof. We do prove things. Koch's postulates prove that a microbial organism, in that case bacteria, causes a disease. There's a step of proof. It's now been expanded to include bacteria, viruses. We prove in chemistry, proof and disproof. And even in simple physics, we prove things just in theoretical physics, we don't, but that's the standard. It's the basis for epidemiology and biostatistics, because we're not proving that the substance causes the harm. We're disproving that it doesn't. And that messes up everything and has no resonance in the legal standard, but Daubert incorporates it. The second is whether the material has been, or the testimony has been subjected to publication and peer review. And as we all know today, publication and peer review is not worth very much. Then the court talks about its known or potential error rate, and that, of course, is reliability. That's accurate. The next one is new from a particular court. This is not in the original Daubert case, the existence of standards. And the last one is widespread acceptance in the scientific community. So the court incorporates Frye and says you can use Frye, but you don't have to use Frye. It's not required. But if you want to use it, you can use that as a way of ascertaining the soundness of the science. They don't use those words. They use the reliability and the relevance, which have very amorphous meanings in the science. So those are the Daubert tests, and that pretty much governed the cases. Now, interestingly, even when Rehnquist wrote his opinion, he wrote, I don't think the judges are going to understand this. And I had the privilege of actually meeting Rehnquist and discussing scientific evidence with him. He said, I don't think judges are going to understand this. And there were surveys done, but judges didn't understand any of this stuff. What the standards did show is that the judges now were more sensitive to what they had to do. There's a trilogy of 3 cases that are used, the Daubert trilogy. General Electric versus Joyner is the second in the trilogy, and Monsanto, poor Monsanto, is involved in this case too. And it's about the exposure to PCBs and lung cancer. The facts are, the plaintiff wanted to prove that Mr. Joyner's lung cancer came from dioxin and PCB. They used my studies, which the court said was irrelevant to humans. And the epidemiology studies were either irrelevant. They pertain to situations that were not relevant to this case. And the experts didn't say what the studies said they said. So the court ruled that the methodology must be sound, and the expert opinion must flow from the evidence, and they use the word no ipsa dixit, that's straight out of Joyner, and it means that the expert's testimony doesn't come in just because I said so, ipsa dixit, I said so. There has to be a connection between the conclusion and the data. So the court believed that the experts did not rise above subjective belief or speculation, and so Joyner now focuses on science, on the conclusion. So this comes from the case, the requirement to ask judges to make conclusions when a case arises in an area where the issue is uncertain. So in the case, we see that even Joyner too is focusing on novel science. This particular concurring opinion comes from Justice Stephen Breyer. Now, Stephen Breyer was one of the few judges who really was interested in the science. He wrote a lot about scientific evidence in the court. And just to show how he was sophisticated, he writes, modern life depends on the use of artificial or manufactured substances such as chemicals. And therefore, it's important, particularly, to see that judges fill the Daubert function because we need those chemicals. We can't just routinely exclude them. And then the third case in the trilogy, which I don't think adds much, is the Como Tire case, which basically says that the laws of Daubert and the laws of Joyner apply to all experts, not just scientific experts, but it does review the 4 factors from Daubert: peer review, error, scientific acceptance, and helpful in terms of reliability. So that's why I'm just there for completeness. That's the Daubert trilogy. So did Daubert make a difference? Do you think everything would change after Daubert? Well, as I said, there were studies that showed that the judges didn't understand it, and the plaintiff's bar was saying Daubert favors the defendants. The defense bar was saying Daubert favors the plaintiffs. What did the statistics say? So Rand Corporation did a study. And if you look on this study, the top line, the dark solid line, is the percentage of times that an issue was raised, the reliability of the issue was raised, and the bottom line is the percentage of the time that the expert was rejected as unreliable. And you see between Frye, or before Frye in 80, the high point of junk science, and 93, Daubert, Frye, that the courts are excluding more experts. The percentage of admissible experts goes from 40 to 60, or they're excluding, they were deemed unreliable now more times than less. And so afterwards, after Frye, we're now seeing that, boy, the plaintiffs are getting, before Frye, what was happening before Frye is more and more experts were being admitted. You see that the courts are not rejecting expert testimony. The amount of times that the courts are rejecting expert testimony is decreasing by half. Starts with 80% and goes to or 60%, about a third. And so judges before Frye are letting in junk science, just as everybody was screaming they were doing. That's what the evidence shows. Okay, so so Daubert comes along in 93. And boy, now judges start excluding them. We start going all the way up. So now judges are excluding experts. You see the huge change. Before the Frye mark, the experts are coming in, the percentage of times that the experts are excluded decreases significantly. And after Frye, they're now being kept out of court. Now, in 1997, when Joyner comes out, you think that would even cause things to get even dicier for the plaintiffs, because now the courts are saying that the experts can say whatever they want. Their conclusion has to be tethered to the data. There can't be ipsa dixit. They can't say if they say so. And what happens? Goes back down. And if you compare the results in 1980 to 1999, they're exactly the same, or pretty much the same. So basically what this chart showed us is nothing changed. There have been thousands of articles, law review articles written about Daubert, the importance of Daubert in 702, which codifies Daubert, and basically it doesn't make a real difference until recently. And I will tell you, there's been a sea change recently. But what the judges did then, or what the courts did then, and what the legislature did, they codified, they made Daubert into a federal rule. They said that judges have a broad discretion, but they still have to be gatekeepers. They said in some cases, the courts abdicated that duty. And basically what they were saying is, up until now, where a judge wasn't sure, they would let the evidence come in and throw it to the jury and say, okay, jury, you decide. It would go to the weight of the evidence is what they decided. And in Rule 702, they said, no, you can't do that. You have to decide, judge. So we have Rule 702, which codifies Daubert. It doesn't really include Joyner, although Daubert and Joyner are the standards. And in December, there was an amendment to 702, which I think people have made a big deal. That's nonsense. The amendment has no real difference, with the exception of in isolated courts. In the cases that we're concerned with, the multi-district cases, the big cases, we have thousands of cases. You have judges who've been in this for a long time, who understand what's going on, and they don't need any amendments. And I'm going to show you what the amendment is, and you can make your decision. So the original rule said a witness who is qualified as an expert, and there are qualifications, can testify by opinion if the expertise will help the jury, that's A. If B, the testimony is based on facts and data, and C, the testimony is the product of reliable methods and principles. And you see, they're only talking about reliability here. They're not talking about valid. And you'll see at the end how they get into trouble by not doing that. And this is the first part of the change. This is what the change is, the new change. They added this. The expert can testify if the person proposing the data demonstrates that it is more likely than not. Big deal, obviously. Basically, it basically says is the person who's offering the proof has the burden of proving these facts. And so if the evidence is in equipoise, if the judge doesn't know, then the judge will decide against the proponent. Basically, that means the judge will decide against the plaintiff, But defendants have science they want to introduce, and if they don't satisfy this burden, the judge will decide against them. So that's what this does. And basically, it only applies if the evidence is exactly equal. If the judge can't possibly find any reason, which is basically nil to non-existence, at least in those cases, the multi-juristic cases, the big cases, or the class action. The second part that the change was, instead of the expert has reasonably relied on these facts, it now says the expert's opinion reflects a reliable application of the facts. I don't really think that that makes any difference whatsoever, and most people in the know agree. It might have a difference in an isolated case. If you have a case in a small town or a singular case where a judge is not familiar with Daubert, this now makes it clear that the judge has to hold the opponent to the standards of evidence. But other than that, it has basically no real effect. And you saw this in Judge Robin Rosenzweig's opinion, which was a year and something ago now, in the Zantac cases, where she basically just threw out the plaintiff's testimony saying that the experts were cherry picking. She didn't need this, she just threw it out on her own. And the explanation is the judges cannot presume to let the jury decide. You can decide whatever you want, jury, and I'll tell you that if you don't believe the expert too much, or you've got a question and you're not sure, it goes to the weight, not whether the sufficiency, not whether I can exclude it from the beginning. And this is the standard of Daubert. The gatekeeper standard means that the judge has to make a decision. They can't say, I'm not so sure, let the jury, and if they don't like it, they can weigh it. The judge must make that decision, and the clarification makes it a little bit stronger, but as I said, judges in the know knew. And so the opinion has to be based on reliable application of methods, and the courts will give more scrutiny to the conclusions, not just the principles and methods. So there has to be a tie-in. So what's the difference between a reliable and valid, and where do the judges get messed up? So let's look at the weather. Today, the weather forecast isn't so bad, but those of us who are here today can remember when the weather reporting was not particularly reliable. And that meant is you did not rely on the weather forecast to decide whether to bring an umbrella. And my husband always says, if you want to know if it's going to rain, if it's raining, look out the window, because many times the weather forecasts get it wrong. So that's reliable. How many times does the prediction come true? The predictive value, you have that in laboratory test, the predictive value of the laboratory test. There are false negatives, there are false positives, but if on the whole, overwhelmingly, we can rely on the test, then it's reliable. But it's valid. Valid means that the theory is based on sound principles of science, plausibility, biological or chemical. So my grandmother was great at predicting the weather. Her predictions were very reliable, and she relied on her arthritis. She said, oh, it's gonna rain, my arthritis is acting up. And she was 100% reliable, but it's not valid. There was no scientific underpinnings for establishing that arthritis is a good predictor. So there's valid as opposed to reliable. And here's the problem in real life. The courts basically focus on reliable. In the case of Lewis versus City of Chicago, and I had the honor of having the judge, Joan Gottschall, in one of my scientific evidence seminars before she decided the case. And she was so thankful because the case involved whether the testing for firefighters was discriminatory against Blacks. And of course, the plaintiffs argued it was. The defendant said it wasn't. And the plaintiff said, but it's reliable, it's reliable. And they would parade experts in and parade experts in and parade experts in. And reliable just meant that every time they gave the test, they would get the exact same result. But the test asked questions that had nothing to do with firefighting. It was a test that wasn't valid for the purpose for which it was intended. It wasn't useful to determine whether somebody was to be a good firefighter. So it was very reliable. They got the same results all the time, but they didn't get valid results. They didn't get results that were designed to prove what they were supposed to prove. Now, here's the problem in science. Very famous case written by a epidemiologist from Harvard named Brian McMahon, published in the peer-reviewed journal of the New England Journal of Medicine. And Brian McMahon says that coffee causes cancer of the pancreas. And it's very reliable evidence. His evidence is statistically significant, and he does male and female and competent, no problem. And when you learn about this case in public health, they say, well, because obviously that's true, it was wrong. How did he get it so wrong? Well, he picked the wrong control group. You know, and they, what do you mean you picked the wrong control group? It was a methodological flaw. Bullroar. What he did was, his original hypothesis was that smoking causes cancer of the pancreas. And so he picked people who were smokers. At the end of the study, there was no association between smoking and cancer of the pancreas, but they noticed that the coffee drinkers had more cancer. So they just switched the results, and said it was the coffee causing the cancer. And so, of course, the controls were wrong because they were selecting people who would be good controls for smoking. It was not a valid study. The hypothesis was designed to prove that smoking caused cancer, and they switched at the end based on their observation. It wasn't the method was not designed to prove the hypothesis. And that's where you get into trouble in medicine. And that's where you have to really understand, is the test or the method valid? Does it prove what it's supposed to prove? And also, is it reliable? Are we getting consistent results? So we can throw away those studies. And here are the dilemmas. Peer review is not what it was. As we all know, there are numerous studies that are being withdrawn. It's not valid. You can't rely on it. And it's not valid because we know that you can't rely on it. So it's not accurate. It has a high error rate, and it's not useful to prove that the scientific community proves it. What happens when a recognized body is provably biased? So this is what happened in the Roundup cases. You have the IARC, the International Council on Science, on Research and Research, saying that glyphosate is carcinogenic. They were biased, but under Frye, that's admissible because it's a general consensus. And then you have cases where validity and reliability are confused. Courts are getting involved in medical issues where they shouldn't. The lawyers are supposed to educate the judge, and they don't, and neither knows enough. And so with that, you understand a little bit about how Roundup is going the way it does in the state courts, because the courts have really no flexibility to keep out the IARC study, while in the federal courts, it's not reliable. And so on good cross-examination, and they're not always good, although the last one I watched, the defense lawyer was excellent, the judge will keep it out. And so, thank you for listening. Tom, are you there?
There we go.
Okay.
Unmuted. Do you want to turn the screen back over so we can get full screen for everybody?
There we go.
All right, Jeff, Nigel, you have any questions?
Not immediately. No, it was very interesting. A bit complicated for me, I must say.
I got a
It is
question.
law.
Oh,
Law
can
is
you,
always complicated.
yeah. Can you hear me, Tom?
Yeah.
Oh, okay. Barbara, with the judge as a gatekeeper, how and you're one of the attorneys, and you're trying to bring in an expert witness, and the witness is not allowed by the judge. Is that something that's appealable so that the next court above can either allow or not allow an expert witness? And Does that only come after the trial, or can you do that before you actually do the trial and have the appellate court force the issue?
Excellent question. So in a Frye jurisdiction, remember, in the 43 states that use Daubert, it's appealable immediately. But the standard of review is that the review courts, and I haven't seen any state review appeals, but the standard of review, excuse me, is only a clear abuse of judgment. So basically the standard is, unless it's really obvious, I mean, it's got to be really in your face obvious, they're going to let it stand. But at least in state court, you can appeal it immediately. In federal court, the case has to be over. Now, for the most part, if the judge excludes all of the experts, the case is over, and so you can appeal it immediately. But again, the same standards. The judge has to truly goof up. If the judge allows some of the experts in, and so the case isn't over, technically speaking, the appeal wouldn't happen until the whole case is over.
And the other question was, can a judge exclude a certain class of expert witnesses, or is it only a particular person because that person either does or doesn't have the right credentials or whatever the background is?
So the credentials are obviously well, not really. The expertise of the defendant, of the experts, is often dependent on the individual expert. However, there are cases where classes of experts are ruled allowed to testing or not. So, for example, biomechanics, people who are have expertise in biomechanics can testify on general causation, on did a particular force cause, can a particular force cause a harm? Can this type of car accident cause a harm? A biomechanics expert can testify, but biomechanics may not testify as a class on whether the individual plaintiff is injured as a consequence. That has to be the examining physician. So there's an example of the class, but generally speaking, it's individual. In the cases where the expertise, where the testimony doesn't flow from the data, the judge has to go through expert by expert and look at the study and what the expert said. But that's what's remarkable, not just about Judge Rosenberg's decision in Florida and Zantac, but Judge Coate on the Tylenol case. They went through every single case and every single study. This expert used this case doesn't work. This expert used this, they went through every single expert. I mean, the cases are hundreds of pages long. The decisions are big. And so they have to do it individually.
I was thinking of, if I was a lawyer, I might go expert shopping, and I would try to find somebody that would agree with me. But for example, it might be a case where the individual's my age, 70 years old, and you find a doctor that was a pediatric specialist, and the court might say, well, you know, pediatrics is different than like old age guys me like. So it seems to me that a lot of times, it seems, judges will give some leeway to allow some of these people to come in if they think it's close. But if they're not close, they'll say, you know, you're too far afield. We're just not going to let this happen.
So as a defense lawyer, we would call those people, you said shopping around. I hope this is allowed to say on tape. We would call those people whores. That's what we called them. You know, they got paid for their testimony. So if that answers your first question. Yeah, and the answer is yes. And your job as a defense lawyer is to show that. And if you're a good defense lawyer, you can show it. Judges, juries are pretty smart. Maybe not, their IQ individually may not be so great, but boy, when you get them together, they get it. They get it. If you do a good job cross-examining, and there are techniques. as to whether the judge, what was the second question that you asked?
Well, it just about how close you could be to be considered an expert. I mean, can pediatrics make comments on old people, you know?
So basically, in the biomechanics cases, of course, those are a different specialty. And the judge will look at what the field of the expert allows. So basically, most MDs are allowed to practice outside their specialty. But I mean, they don't, but they're allowed to. So if you are a bona fide MD and you've done a residency in internal medicine, you can do brain surgery. You don't, because your malpractice premiums will go off the roof, but you're legally allowed to do it. In the shaken baby cases, which I'm working on now, I'm reading this article by a bunch of lawyers saying that there is no such thing as a shaken baby. The diagnosis is unreliable because we can't prove it. Of course, you can't prove it. You're not going to take a bunch of babies and shake them, but that's what their argument is. And they have, as one of their co-authors, a woman whose name I knew. And I said, I know this woman's name. What is she doing in this case? She's a breast cancer radiologist. She is very famous as a breast cancer radiologist. I mean, that's how I knew her name. And she's now, but she apparently is qualified as a pediatric radiologist. I don't think she has ever practiced in that field, and yet she's signed on to this to make a name for it. So they're allowed to be admitted, but that's where a good cross-examination would say, and doctor, how many brain surgeries have you performed? And the jury will get it very good. It would be a dumb thing to do, not that it's not done, because a good cross-examination will expose that.
But that means having a competent attorney. So I sat on a case. I sat on a case that involved the scalding of a child, second-degree burns, and the ADA claimed that the father, who didn't live with the mom and baby, had taken the child and cleaned it by putting it in scalding water in the sanitary tub, which is right next to the water heater. The first testimony was by a person who said that it had to have been done in the sanitary tub because the water would be too cool if it went to any other location in the house. That was his area of expertise. Then the ADA brought on somebody who testified as to how hot the water would have to be in order to scald the baby with second-degree burns and how long they would have to be held in the water. And then the defense attorney then asked that person, is it possible that the water can stay that hot if it travels to the bathtub upstairs? And the guy said, well, I imagine it probably could, but that wasn't his area of expertise. Me and another juror took about 30 minutes trying to explain to the other jurors that this expert's testimony in this area is his, and he's solid there. This one, he's solid here, but he's not solid over here. So that testimony, the judge should have questioned it, as the ADA should have said, where's your expertise in that? But she didn't. But anyway, we ended up.
But it shows the importance of the jury, and it shows, and this happens in the jury. The juries talk to each other, and you have jurors doing that kind of thing. And yes, this is something that should have been picked up by. But the thing is, I don't blame the judge. It's the lawyer that's supposed to bring it up to the jury.
The ADA should have done that.
Absolutely. And in this case that I'm working on, this New Jersey case now, I'm looking, how did the DA, was it DA in that case? How did the DA even not question?
Yeah. Any other questions? Okay. Well, I thank everybody. Thank you, Barbara, and thank everybody for joining us today. And I'm hoping to have the next Salk Talk, I like that, probably sometime in early June. My May's really messed up, so I'll have to wait till then. Thanks, everybody. Take care.
All right. Thank you.
Thank you very much. I didn't have questions, but I really appreciated it. Thank you.
Thank you. Thank you. Bye.
And this is being recorded, so I'll send out copies of it to everyone.